Thank you for attending the meeting. While we invite the administration team to come in, let us talk about some house matters. I'd like to remind you that at the meeting on the 2nd of July, we have already decided that in the first meeting of the Legislative Council session this year, there will be a resolution in order to extend the scrutiny period of this bill or regulation. Our first council meeting will take place on Wednesday, that is tomorrow, and I'd like to draw your attention to some matters. The original deadline for scrutiny is the 22nd of October, and the deadline for giving notice to move CSAs will be on the 15th of October. But if tomorrow, if we can extend the scrutiny period, that will be extended to the 12th of November, and the deadline for giving notice to move CSAs will be the 5th of November. Well, I believe we'll have a meeting tomorrow, even if we don't know for sure. And so before the 5th of November, you can still give notice to move CSAs. Otherwise, you will have to submit them by the 15th of October as originally scheduled. I'd like also to let you know that at the meeting on the 2nd of July, members asked many questions, and the administration has given us some response. On the 22nd of July, actually, the response has been forwarded to members on the 18th of July. That is CB bracket 2 2070 stroke 13 to 14 bracket 06. And then on the 22nd of July, we met deputations, and they also raised certain views. We asked for a written response from the administration, and that has been distributed on the 26th of September. The serial number is CB bracket 22345 stroke 13 to 14 bracket 01. Members, with regard to these papers and also the regulation, do you have other questions or comments? If not, since these two papers have been forwarded to us 2 or 3 months ago, especially the paper 2070, I think you must have read it. Any questions or comments on them? If not, I think we can start the clause-by-clause examination of the regulation. Okay, if you have no comments. No comments or questions, right, members? If that's the case, let us go on. Yes, Ms. Elizabeth Quat. 4 minutes each for each member, including a response. I'd like to clarify certain matters with online sale. It says that if anyone puts on sale online, it will be a criminal offense. However, if it is done out of Hong Kong, if the website is an overseas website and such products are sold online, you cannot have control over them. And Hong Kong people can purchase such products online. Would there be any criminality or liability for Hong Kong people? As we said in our paper dated the 18th of July, second paragraph, under the amendment regulation, the regulation would apply to any sales or manufactures for sale and advertises for the same on the internet. Now, as to what can be controlled, it depends on the circumstances of the different cases. If the seller, for example, is in Hong Kong, it is just that he advertises for sale on the internet, I believe such a case will be regulated. But we have to look at the unique circumstances and nature of each case before we can come to a judgment. What if it is an overseas seller making sale on an overseas website? Is that you cannot control that? If the circumstances do not comply with the sale requirements of the regulation, then it cannot be regulated. If there is no sale locally, then we cannot control it. Say a Hong Kong person sells on an overseas website products for sale overseas. In other words, the products should not be sold
transaction is made, the products are shipped to Hong Kong. Would that be controlled? I cannot give a general reply. It depends on the actual circumstances of the case. If the seller sells overseas an overseas product, I think it will be difficult for us to control that. But as to the shipment of the product into Hong Kong, I cannot give you a definitive reply as to whether that can be controlled under any Hong Kong ordinances. Are there Hong Kong laws that can regulate this? Maybe the DOJ colleague can give the information. I myself have no information at hand to give a reply. Ms. Ng? Thank you, Chairman. It depends whether the act takes place totally in Hong Kong. As to whether there are laws that regulate overseas conduct, yes, there are. But if you ask for general coverage of acts that happen totally overseas, then I'm afraid there aren't. And this amendment regulation does not exactly extend to cover overseas conduct. So it really depends on the different elements of an offense or the case, so that we know whether the act is caught by Hong Kong laws. Well, Chairman, I understand if the transaction platform is overseas and the seller is overseas, then perhaps we cannot regulate it. That is why I also asked that when the product is transacted and has to be shipped into Hong Kong, whether we can do anything. That was my question. If you cannot answer me today, please give me a written reply. Well, I can say that the offense is written in such a way that there is an act of sale. If the act of sale totally takes place overseas, I think there may be a difficulty. Dr. Vincent Fang, 4 minutes. I'd just like to mention the grace period for the trade. There are 24 months for some products and 18 months for another product. We'd like to ask you whether you can allow all 3 kinds of products the same grace period of 24 months because they may have to reprint the outside of the cans, and a lot of the procedures are taken overseas and the time taken is also long. I hope you will not be recalcitrant on the difference of 6 months so the industry can have more time and so that there is consistency. Even if there is a longer period, meaning 6 more months, I'm sure there is no adverse effect on the implementation of the regulation. That's a very modest request. Why don't you just accede to it? PAS. Thank you, Dr. Fang. Last time, when we met deputations, there was repeated discussion on this, and we went back and also thought about it. But we still hold the view that, in fact, infant formula is the main source of nutrition for babies relying on such a product, and we therefore have the responsibility to ensure that the product can meet the nutrition requirements of babies. So we have set a shorter period for such a product, but we heard from the industry last time that they would have to have enough time or sufficient time in order to make preparation. Since the last meeting, the Center for Food Safety issued the technical guideline very soon, because the industry said that they would like to come to grips with the lab test product, the procedure, and also the tolerated limit, etc. And that is why the CFS wasted no time in disseminating that kind of information to help the industry get prepared. And therefore, in terms of the grace period, we would still like to maintain it at 18 months for infant formula and 24 months for the other 2 kinds of products. Well, I wouldn't like to move a CSA, but the administration always forces you to move CSAs yourselves. Whether or not the regulation is past, I would ask the administration to be understanding. You never budge, and that is why there are so many voices on the streets. So if you are forcing me into such a position, I have no choice but to move a CSA, and I must say I cannot see where you are coming from. Okay, the administration, I'd like to ask you a question on the question raised by Dr. Fang. Your paper tells us that that is in para 19, that amongst the infant products, those that do not comply with the labeling requirements would be higher than that for follow-up formulas. In other words, there are more infant formula producers which cannot comply with the new requirement. There are 20 of them and only one for follow-up formula. Dr. Fang's worry is that if there are only 18 months for infant formula, in fact there are more producers or manufacturers who cannot comply with the new requirements, so there is more for them to do. So have you considered the difficulties met by the trade, and they would need more than 18 months? Thank you, Chairman. As you see in para 19 and also in the LegCo brief, we have stated in the annex that in terms of infant formula, with regard to the composition, from the survey done by the CFS, over 70% of the products can already satisfy the composition and labeling requirements of the new regulation, and only 20% of the products cannot comply. We believe such a survey result allows us to have the confidence that in fact the compliance rate is not that low, so low that they may need a grace period of longer than 18 months. But from your survey, if you put infant formula and follow-up formula together, the compliance rate is 70%. But if you separate the two, there are more producers of infant formula who cannot meet the new requirements than the producers of follow-up formula. But what you do now is just the opposite. You allow a shorter period for those who cannot comply. Chairman, I think we need to strike a balance. Your observation is correct, Chairman. There is a difference between the compliance rates.
Well, the percentage of infant formula products meeting with the requirement is lower compared to the follow-up formula products. But we have to note at the same time that we would like that babies relying solely on infant formula can, as soon as possible through our amendment regulation, be provided with products on the market which can meet international standards. Well, while we promote breastfeeding, but in reality, a lot of people are on infant formula. This is the reality that we are facing. Well, I understand your objective, and we understand your objective in protecting the health of babies and infants. But you're talking about a grace period of shorter, and then how can you convince them that these producers of infant formula, they have to do more, but then they are giving a shorter grace period? So this is the worry of the trade. So what can you do to help them? Well, I don't want to see the situation where we have to move the CSA on this. Well, we have done whatever we can. 2 months ago, the CFS, before we issued the draft technical guidance notes to the trade, in fact, during the drafting of the regulation, we have communicated with the trade, and as early as last year, we've told them what the amendments would be, and the trades have already got some time to make preparations in advance, so I believe they do have sufficient time. So first round, any other member? If not, second round, Dr. Vincent Fang, 4 minutes also. I want to clarify. You said the government said that they have been communicating with the trades. What do you mean by that? Well, does it mean that you're just talking to them unilaterally, and I won't take in your views, and I will do whatever I want to do? We're talking about extending the period for 6 months, from 18 months to 24 months. What sort of impact will it have on the babies? If there is no impact at all, why do you have to make things so difficult for the trade? You said you communicated with the trade, you had meetings with them, and you just stuck to your way of thinking, and you were not listening to them. So I don't think there is any real communication going on. Perhaps I'll defer to Dr. Ho from CFS to supplement. But in communicating with the trades, apart from the grace period, we also discussed what the amendment specifically would be, and also the testing methods, technical issues like those, so that they could get prepared in advance and they could have more time to do the preparation. So perhaps Dr. Ho can supplement. Thank you, Madam Chair. On this amendment regulation, we held a few rounds of technical meetings with the trades. And specifically on the grace period, we had some discussions. And in one of the discussions, we focused specifically on the grace period. And during our discussion, we heard many views from the trades saying that the grace period may be too short and that would have an impact on them in supplying the products. But when we said that if it is going to be 18 months for the infant formula and then 24 months for the follow-up formula, some trades said that they would face difficulties in doing that. But some others said that 18 months is enough for them to make the relevant changes. So we've heard views from both sides. And also some people in the trade asked for that we provided the technical guidance notes as soon as possible so that they can proceed with the reformulation and the labeling and so on. And so that's why after the last meeting, we held another special meeting to talk to them. And we've also given them the guidelines, the guidance notes, which have already been uploaded to our website. So the trades can go there and take a look and make reference. So this is what we heard from the trade. In terms of the grace period, we are also concerned that infant formula is the only food for babies and infants. So that's why we have to proceed with the regulation as soon as possible. Madam Chair, I don't think there is substance to what the government said. If we are to extend the grace period to 24 months, is there a disaster? Is it going to hurt infants? How many infants and babies will be impacted upon? Have you made some such estimates? Or you just stick to your line of saying the sooner it will be, the better it is? I think it is a matter of striking a balance. Before we did the amendment regulation, we consulted extensively starting from December 2012. During the consultation period, we received views from various sides. Apart from the trades, mothers groups and concerned groups on babies' health gave a lot of views on shortening the grace period. Some even suggested as a grace period of 12 months. Well, Dr. Fang was asking you about whether you have done any quantitative assessment. We're not asking about the comments that you received. Now, if the grace period is going to be shortened from 24 months to 18 months, how many babies will be affected? So, is this what you're asking? We didn't do assessment like that. When we made the decision, we tried to strike a balance so that which is feasible for the trade, and at the same time we can take care of the interest of the views of mothers groups and also medical professions. Can you do an overall assessment or full assessment? What are the benefits that is going to be brought about if there is a change in the grace period? Well, don't just tell us the sooner, the better. We don't accept that. Mr. Kok Wai Kang. Madam Chair, I don't have a child yet. I hope to have one. Grace period. Now we're focusing on this. And honestly speaking, I'm sure that parents are very concerned about this. Well, the shorter the grace period, the better the protection for the babies. Well, this I can understand. But then if this is the reason given in a logical discussion, then that's too flimsy. Now, the nutrition labeling scheme came into effect in 2012, and it doesn't cover children under the age of 36 months old, and 3 years have lapsed. I don't know where your justifications are. It's right that we try to safeguard the health of babies, but then if you are giving us just this reason, the sooner the better, then it's not good enough. Some people said that 24 months is okay. Others said 18 months, others 12 months, and so on and so forth. Now, in your remarks, you didn't raise any figures. Now, you said you have heard many views. So what is the proportion of the different views? And if you are just saying you go by your general impression, then you will give one the impression that you are not transparent enough and you don't have sufficient information to back you up in your decision. So how can you earn the support from the public? We want to get this regulation passed as soon as possible, and we don't want to drag it on. So I hope the government reconsider this. So can you tell us clearly, specifically, what is the negative impact if we extend the grace period from 18 months to 24 months? How many how many babies rather be affected? Is it the case that some manufacturers, the sellers, will be able to sell off the goods in 6 months' time? The life span of the baby formula is shorter, and it's because the batches, there are frequent changes of the different batches. Do you think that it's because of this that they would be able to sort of reprint the labels and change the products faster and so on? Are these the reasons that you are relying on? Now, if you just said that this is the reason is just that you are very concerned about baby's health and you want to do it as soon as possible, so that's not good enough for the electoral members here. Thank you. So I hope that I've got all the questions raised by Mr. Kwok. Mr. Vincent Fang mentioned that whether we have assessed the impact of changing 18 months to 24 months. So first of all, I'd like to tell you why we wanted to have this amendment regulation. Mr. Kwok is right in pointing out that the NLS doesn't cover food products under aged 36 months old. Now, CFS way back in 2012 that there were products on the market with a lack of iodine, and that would affect thyroid glands and also the baby's brain development. So that's why we think that we should expedite the amendment working on the amendment regulation to ensure that products on the market have nutrients recognized internationally. Now, well, no one can tell for sure what is the impact of extending the grace period for 18 months to 24 months? Will that be in other spate of incidents relating to iodine? I don't have the crystal ball. I can't tell you for sure. But I just want to let you know that since these incidents happened, we should expedite our work on regulating on formula products to make sure that babies' health are protected. I have another question. In Annex 4, the information, when was that collated? Annex 4, what was the survey period? Yes, the electrical paper, 2070. Perhaps the CFS colleagues can can elaborate on this. That was outlined in paragraph 19. So in paragraph 19, you mentioned or you referred to Annex 4. The survey was done between 2012 and 2013. You said that you discovered a lot of products on the market lacking iodine. Was that covered under the survey? Is it in the same period? And since then, you haven't conducted any survey, right? Now, do you know whether products now on the market contain more iodine? We didn't follow up on the survey. Of course, the problematic products were taken off shelf at that time. You said that you must expedite with your work on the amendment regulation because you said that you found a lot of products lacking iodine in 2012. And then we are now looking at Annex 4 again. Now, have the products improved with respect to iodine level? You don't have the figures to share with us. Now, if the situation deteriorates, now if you say that you have figures showing that the situation in 2014 has deteriorated compared to 2012, then I would say that we should even have a shorter grace period, 12 months, say, because we want to be more stringent on the infant formula. We want to have 12 months, perhaps, instead of the proposed 18 months. Now, if the situation improves, then it means that the sellers are taking initiative. So perhaps we can take a more linear approach to the grace period. And the trade doesn't have to be worried because the trade is taking initiative on their own to improve the situation. So if you don't have updated figures for us, it will be difficult for us to support your proposal. Well, Madam Chair, let me tackle this from another angle, perhaps. In our brief to the Legislative Council, Annex B to that paper, I also refer to that. At that time, we did a survey. Well, formula products, some 20% of the products could not meet with the Codex standards. So in the market, some products are currently consumed by babies do not meet with the relevant standards.
But those are figures for 2012. Yes, I understand. I don't have the figures at hand, but the CFS can add. But I think that without legal regulation, I cannot see how 100% of the products in the market can meet Codex figures. Well, it's not a matter of whether you believe or not. CFS, did you do a further survey? No, we did not. But the industry knows a regulation will be implemented and they are making improvements. So you are resorting to trust. And I think there is not much meaning to this argument unless Dr. Fang is going to meet or move the CSA. However, we need a basis for doing so. If you want members to accept a shorter and stricter grace period for infant formula, you must update us on the latest situation. You cannot just refer to 2012 figures. I don't know whether the situation has become worse in 2014. If that's the case, then of course we would agree that we should have as short a grace period as possible. I'd like you to go back and see whether you can find some figures and data for us. We need data in order to support or object to you. Dr. Fang, your third round, 3 minutes. Well, we'll be very brief. Just like to add that the PAS said that the iodine content was too low for many infant formula products. I don't know whether when you did your survey that a lot of the infant formula has been imported from Japan. Infant formula made in Japan would be chiefly for Japanese babies. And since Japanese babies or Japanese eat a lot of raw fish, so the mothers tend to have more iodine in them, and that is why the infant formula may not have such a high iodine content. So my question for the Bureau is, when you did the survey, did you take into consideration the fact that the Japanese infant formula was mainly for Japanese babies? And did you look at infant formula made in the US and Holland, and whether there is also a low iodine content? This is not the case as far as I know. Dr. Ho? We did the survey then with infant formula available in the Hong Kong market, and we found that indeed there is a higher proportion of infant formula from Japan that is lacking in terms of iodine content. That is why we said that any infant formula sold in Hong Kong must comply with our legal requirements, including the iodine content. Chairman, my question is, what about infant formula made in other countries? Is this particular to Japanese products? What about those manufactured in the US and the Netherlands? Is there such a low iodine content? From the survey then, there are isolated cases of low iodine content made in other countries, including one from Australia. Okay, everything you said is on tape, and that's good to know. In other words, the Japanese infant formula has not been manufactured for the Hong Kong market. Any other questions? If members have no other questions and comments on the response papers, I'd like the PAS and the CFS to consider updating us on the latest situation. I think we should now go into the clause-by-clause examination of the regulation. Yes, Dr. Helena Wong. I'd like the Bureau to clarify the tolerance limits. I think I asked that question before, and we have got some papers from the administration. With regard to tolerance limits, you are not including them in the law, but rather in the guidelines. Why? Is it then easier for you to make amendments from time to time, or what? PAS. At present, in the nutrition labeling system, we already have such limits. Under the system, the tolerance limits are not included as part of the law. We have had the system for a few years now, and we find that it is time-honored. And we believe we can follow that example and not include that in the law. We can see that many countries also use such tolerance limits, and some countries don't put them in the law either. So Hong Kong is not unique in doing this. I'm basing on what I said. We believe we can continue with the same approach, that this is included only in the technical guideline. Chairman, can I ask the Bureau to explain further I asked this question before. The claimed level and the tested level, you say there will be some tolerance about the discrepancies. And I also asked the indicators for other countries. In your paper 2086, para 18, page 7, you asked us to look at the annex. You include Codex and the EU, etc. So can you take us through those? Sorry, are you talking about paper 2070? Can you let us know how we came up with the present tolerance limits and how are we different from other jurisdictions? Are we talking about paper 2070? No, I believe you are referring to a paper issued on the 22nd of July. You are referring to Annex 3. In response to members' questions, we did a comparison. Can I ask the CFS to take us through that? Thank you, Chairman. You can see from Annex 3 that we listed a few regions and their tolerance limits. The US, the mainland, New Zealand, Australia, Singapore, and the EU. Actually, people have more or less the same inclinations. If there are nutrients that are beneficial for the country, the declared value should not be less than 80% of the declared value. But if some are actually not good for health, then it should not be more than 120% of the labeled values. We are doing more or less the same as other countries. After looking at other countries, we have decided on our own tolerance limits. And they already apply to the nutrition labeling system. After talking to the industry, we think that it is appropriate for us to continue to use such tolerance limits. And what we are proposing is actually consistent with what is applied on other foods. Chairman, can I ask Dr. Ho to explain to us why, with regard to vitamin A and vitamin D, the declared value can be 80% to 180% of the declared value. If you look at the US, naturally occurring vitamins, about 80% only. And other regions, nobody has put it at 180%, meaning it's almost double. Why is it that we feel vitamin A and vitamin D can have such a different level from other jurisdictions? If you look at the USA, it is in one direction only. In other words, it must be over 80%. But it doesn't have a cap. After looking at the approach of other countries, we feel that vitamin A and vitamin D are quite special in that if you lack those two vitamins, it is bad for health. And in fact, it is also bad for health if you have an excess of it. So if labeling is done for these two vitamins, we tend to make it strict. We dictate both the upper and the lower limits. So in fact, we are being more stringent than the US. Okay, members, if you have no other questions, we go into clause 5. Yes, Dr. Fang. Chairman, just now I heard from the Bureau that the test was done in 2012. Can they give us a paper telling us which kinds of infant formula were tested in 2012 and what were the problems found? Just now we understand there was a low iodine content in infant formula from Japan. So you just want the information about the 2012 survey, right? I'm sure that can be supplied. Okay, we go into clause-by-clause examination of the regulation, please. Paper 1933. The Bureau, can you take us through that paper, please? Members, please refer to CB bracket 2 1933 stroke 13 to 14 bracket 02. Please start. PAS. I'd like to clarify, are we now going into clause-by-clause examination? Yes. First, commencement date. We had a lengthy discussion just now, and after this meeting, we will provide further information to the subcommittee. Why don't you start with page 1? Do you have paper 1933? Start with page 1. Dr. Wang, sorry I was late. I don't know whether this was covered. Is this for negative vetting? Yes. In other words, starting from the 18th of June, we should have 28 days. Have we extended the date of scrutiny? Yes, that will be done in our Wednesday council meeting. The date should end on the 22nd of October. And also, members should propose amendments and give notice by the 15th of October. But tomorrow, if there is a meeting, we'll extend it until the 12th of November, and the deadline for giving notice for moving amendments will be the 5th of November. But I have to remind members of one thing. The council meeting, if it is held on the 15th and is going to be able to handle the extension resolution, then we can of course extend the scrutiny period to the 12th of November. But if in case it will not be processed, then perhaps we have to stick to the original date of scrutiny. And if you want to move amendments and give notice, that would be tomorrow. That is not possible, Chairman. I think you have to clarify this with the legal advisor. We have not even examined one page or one clause of the regulation. We cannot cover this within an hour. Well, so we are going to make the extension. However, you said there would be a risk, and if we cannot do so this week, then the extension will not be done and the scrutiny period will be over. Well, that is why we are starting to do it. No, you will not have enough time to go through it. Well, that is better than not starting at all. No, you cannot say that. Sorry, please listen to me, Dr. Wang.
We will do our best. The President knows that we are asking for an extension, and he clearly knows that we are doing that. But I just want to remind that there has been so much chaos with regard to meetings, and so that's why I'm reminding you of this point. The extension should already have been made last week, but then the President knows well that we have to extend the scrutiny period. Well, please pay attention to that, because we should be allowed time to really move the amendments, if any. Okay, let's go to these clause-by-clause scrutiny, page 1. Sorry, Madam Chair. No amendment in the first page. Page 2. The definition of the term energy, some changes are being made. to reflect the definition and the codex. Oh, okay, let's move on. Page 3. Vitamin A. Likewise, for products to be regulated, we are also incorporating the definition of vitamin A under Codex. Next, nutrients. We're making an amendment to add in nutrients which come under our regulation, our amendment regulation. Page 3, any question? If not, page 4. We are changing or amending the list of nutrients to include a list of the nutrients to be labeled in the schedule. And then we add in a new term and its definition, and that is formula for special medical purposes for infants and young children. Because in the market, there are such products for infants and young children with special needs. And that definition is also modeled after that under Codex. All right, let's move on. Page 5. No. Page 6. No amendment. Page 7. Sorry, well, the paper I have on hand is different from this other one. Well, perhaps I would respond to Dr. Helena Wong. Because negative vetting is causing all the problems that we're facing today. So we must remind the administration of this point. So we are facing a lot of difficulties. Page 7, 1A. In our definition of follow-up formula, since in the market, apart from there are different types of follow-up formula, number 2, number 3, or number 4. Now, 1A is there to ensure that when we define follow-up formula, we would be including all the products available on the market. 1B. There are some infant formula or rather some infant formula can be consumed by older children. For example, the products are fit for consumption by those between 0 to 24 months. So babies in both categories can consume such products. So under the circumstance, our policy intention is that such products should be under the more stringent guidelines as applicable to that to infant formula. So 1B is there to serve this purpose. No question? Then let's go to the next page. Page 7, towards the bottom of the page, there are some other amendments. Section 3. Well, let's tackle Section 4 first. In the nutritional composition, the FSMP would be exempted. So Section 4 is there to provide for that exemption. Well, they have different kinds of nutritional composition, and it will also vary from product to product to meet with different needs of infants. So we can't ask them to abide by the 1+33 formula. So hence the exemption. As for Section 3, there is addition to Section 2, so we add into subject to paragraph 2 here. Hence this amendment. Page 8. In 4A, in subparagraph 1, we want to add in 4C, and that covers the three kinds of products: infant formula, follow-up formula, and formula products and packaged food for infants and young children. So we add that in. If there is no question, let's move on to page 9. In paragraph 5, so originally we said subject to paragraph 6, but we want to add in the paragraph 7. If the three types of products, infant formula, formula, or prepackaged food, may be consumed by people about 36 months old onwards, and such products actually come under the nutritional labeling scheme. So these products are fit for consumption for both categories of people. So if that is the case, the infant formula, formula, or prepackaged food should also be subject to the same regulations now applied under the nutrition labeling scheme. So this is at 7, and then we want to add in this paragraph 7 to the original 5, paragraph 5. 4C, we want to add in 4C. Has to do with nutrition labeling of these three types of products. Subparagraphs 1 and 2 is that requirements on such products are provided for in Schedule 6A. And subparagraph 2 says that Schedule 6B are exempt from the requirement of paragraph 1. And 6B has to do with exemptions including FSMP. So they would not be under the regulation of nutrition labeling because the nutritional composition may be very different. Other exemptions in 6B are that if, say, the packaging, the total surface area of package under a certain limit, then they are exempted. For formula products, if the packaging surface area is below 250 square meters, then that is exempted. And for prepackaged foods under 100 square meters, that's also exempted because they don't have enough space to list out all the nutrients. Now page 10, paragraph 5. If the nutrition composition doesn't meet with the requirements, so there is no offense. So it's fine at level 5 and imprisonment for 6 months. Page 11. Dr. Helena Wong. Madam Chair, I'd like to ask a fine at level 5 and imprisonment for 6 months. On basis, did the government propose that penalty? Do you think it is deterrent enough? A fine of at level 5? We think this is an appropriate penalty. This is the existing penalty.
This is just to reflect that with regard to infant formula, the penalty is already at a fine of level 5 and imprisonment for 6 months. We are just preserving it. We think it's desirable. Dr. Wang, yes, please carry on with your question. I think $50,000 being the fine may not be enough because we are spending so much time on making this regulation so that we understand the infant formula is good enough nutrition for babies. We have labeling 1+29, 1+33, and then we set the tolerance limits. We are very serious about this. And therefore, we also hope that the sellers themselves would also be serious about this, that they follow the indicators to the letter. But of course, there are some people who are unscrupulous, whether they're intending to do it or not, and the products do not comply with the indicators, and yet the fine is only $50,000. What kind of deterrent do you think at this time and age? I'm aware that under the relevant ordinance, the fines are not that heavy. But don't you think food safety is something serious? If infant formula is the only source of nutrition for babies, and even if people break the law, the fine is only $50,000, I mean, that is already the maximum, and they can be fined as little as $5,000. I would ask the Bureau to really consider this again and consider raising increasing the fine if people break the law. PAS. Is Dr. Wang meaning that we review all the fines and penalties. No, just for this one. As I was explaining, with regard to nutrition labeling, we use the same kind of penalty. If it is a serious offense, say for example, the product is seriously unfit for human consumption, we have other ordinances talking about this. For example, the Public Health and Municipal Services Ordinance, and if something is unfit for human consumption, the fine is at level 6. By comparison, we believe the present fine level is appropriate. Dr. Wong asked for an overhaul or a complete review on fines with regard to food safety. I think I have to take this back to the Bureau, and I cannot give an answer here and now. Chairman, to assist us with a comprehensive understanding, can the Bureau let us know the penalty for regulating the quality of food items? Can you let us have a table so we know the range of the penalties? If all the penalties are not deterrent enough, then we might want to overhaul all of them. But here we do not have the information. Can the Bureau let us know that information at the next meeting? And then members might want to consider for themselves whether they'd like to move any CSAs. PAS, the member is asking us to tabulate penalties with regard to food safety. I can do this as soon as possible after the meeting. I understand the next meeting is on Friday. I'd like to go back and see whether we can do it by Friday. Ms. Sitho, I am sorry I'm late because I had to receive an Australian delegation. Can I go back and ask a question? I have prepared to ask this on about page 3 of the marked up copy, and that is about the nutrients. Last time the Director of Audit released a report talking about nutrition labeling for infant formula, and he mentioned that in fact in Japanese infant formula the iodine content tends to be low. Sometimes it's even absent because Japanese people already eat a lot of seaweeds and fish, and so they are not lacking in iodine. But for Hong Kong people and people from other regions and places, they may not be able to absorb so much iodine from their diet. If you do not take, for example, dry seaweed as part of your sushi, for example, then therefore the Audit Commission released the report, and this was discussed at the PAC. A lot of Japanese infant formula is sold in Hong Kong, so shouldn't they also label the iodine content to let people know that it is very low or even absent? Under interpretation, talks about new protein, hydrocarbonates, and also I believe you should look at B, C, and that is to preserve bodily functions, and that if there is a deficiency, then there may be impeded growth or physiological changes, etc. So are you considering requiring such infant formula manufacturers to include a declaration on iodine, because indeed Japanese infant formula is available in Hong Kong? PAS, can I ask Dr. Ho to supplement? Dr. Ho? Thank you, Chairman. In terms of nutrients, in Schedule 6A, we have included the nutrients which are of concern to us. And under 25, we have iodine. Nutrients that are important for the growth of babies are already listed in Schedule 6A. We stipulate that some nutrients have to be labeled, and then there is also a content level that is stipulated for certain nutrients. So does it mean that in future, the list of nutrients from 1 to 29 in Schedule 6A, all those have to be labeled and listed? Or is it that when lab tests are done and if these are found to be deficient, what are you going to do? Exactly, all 1 to 29 would have to be listed and labeled. Okay, then you have answered my question. Thank you. Thank you very much. Thank you. Mr. Wang Ting-Kwong. Thank you, Chairman. With regard to the penalty level, I understand we have different penalties for food safety, but here we are talking about food and drugs composition and labeling. In other words, we are talking about the labeling. And so the fine applies to the labeling instead of food safety per se, because that is regulated by another ordinance. Is that right? PAS? I was trying to say that Dr. Wong asked about the fine at level 5, whether it is too lenient. I was trying to picture a situation whereby the labeling or a composition error is found for an infant formula, and that leads to food safety problems. Say, for example, if an important element or nutrient is lacking in an infant formula, then depending on the severity level or extent, we can invoke the Public Health and Municipal Services Ordinance in order to state that that food item is not safe for human consumption. And in fact, with regard to food safety, there is a fine of level 6 for certain offenses. But here, for this regulation, it may be a labeling problem, and so a fine at level 5 would be appropriate. And Dr. Wong says that we should review the situation, and we are going to supply that table or checklist. We will give all the information. If my understanding is correct, this is not the same as food safety. We are talking about labeling of food products. I think the two are separate matters. This regulation has to do with labeling and composition. In other words, that people do not comply with these two parts, and so we need the regulation. And the fine, of course, is made according to the nature of the regulation. But food safety is regulated by another regulation or law. Is that right? Yes, your understanding is correct, Mr. Wong. If there are no questions on page 10, let us go to page 11. Shall we continue? Yes, please. Page 11. We added 1AC. It is a provision on penalties, and they cover infant formula, follow-up formula, or prepackaged food for infants and young children. We are talking about prepackaged food as well. If the law is broken, again, the fine is at level 5. Under 1B, there is an amendment. We add 4C. Originally it's 4A and 4B. Now we add 4C. And 4C really points to the requirements of the labels for the 3 kinds of products. Under 1B, or this provision says that if you are not responsible for the marking or labeling, and you are not the manufacturer or packer, but you alter, remove, or obliterate the marking or labeling, then you break the law. And this is actually a labeling requirement. A. It is about publicity. Sorry. You talked about 1B. We say you ask people to list 1 to 29, or you require 1 plus 33. If the label itself includes 30 or 31 nutrients instead of 29, but then since the law says 29, so he crosses out 30 and 31. According to 1 B, does it mean he breaks the law? Because the label itself is intact, is all right. It includes 1 plus 29. It is just that the person crosses out whatever is not required by the law. Can I ask the DOJ to answer the question? Ms. Ng? I can add one point. Under 1 B now, it targets people who are not the manufacturer or packer originally responsible for the marking or labeling of the food. It targets third parties who alters or removes or obliterates the marking or labeling of other people's products. This time around, the amendment is really to add 4C. In the Chinese version, we also take the opportunity to improve the wording and styling of the provision. The effect is to add 4C. The offense targets the third parties. In other words, without the consent of the original manufacturer or packer, right? I'm saying this because the product might not have been manufactured just for Hong Kong. So the label may be 1 plus 31 instead of 1 plus 29. And if the manufacturer says, I don't want to subject my product to a test because of 2 extra nutrients, so he takes it to the selling points and asks a salesperson at the retail point to cross out number 30 and 31, and then the salesperson will be held liable because he is not the original manufacturer or packer. Well, we can understand that if this is directed by the manufacturer, then that means there is authorization, and perhaps this person will not be regarded as not the original manufacturer or packer. However, it depends on the merits of each case. If the manufacturer decides that the label can comply with the new labeling requirements and still he wants to alter it, then I don't think this is caught by 1 B. I'm saying this because I like to protect the interests of frontliners. Your answer is that there would be authorization, but as the law stands, we cannot see any mention of authorization. If a frontliner is asked by the boss to do it, well, this may not really happen, but we have to take care of that eventuality. Do you get what I'm saying? Perhaps I should go back and discuss it internally so I can give you a more comprehensive reply. But 1B is an existing provision. Well, I understand. I'm saying this because I like to take the opportunity also to attend to an omission. Your message to us is that this in fact implies authorization. However, this is not seen from the writing of the provision.
Yep. 1 B relates to the person not being the manufacturer or packer originally responsible. So it depends on who is making the alteration, whether he is the original manufacturer or packer. Okay, can you go back and take a look to see if this can be amended? Please continue. And then now we move on to 2 A. And that has to do with advertising and publicity. Now, if you advertise this for sale of our regulated products and the products don't meet with the nutritional composition required, then that constitutes an offense. If that happens, i.e., when you advertise your product, but then your products do not meet with the nutritional composition and labeling, the defendant, if he can prove that he is doing it on another person's behalf, say an advertising company, is authorized or commissioned by the infant formula seller to do the advertising, then he can use that as a defense. Well, then I would like to skip one part and then go to 3B. 3B, it's similar to 2A. And that has to do with the label. If the label doesn't meet with the law, but then you are being commissioned to do that labeling. So it is a defense for the defendant to show that he is so commissioned. There is a corresponding amendment to 3. So can I defer to the D of J colleagues to explain the corresponding amendment in 3? This is a technical amendment. The present 3 mentions possession. So we are regulating the sales and not the possession. So that's why in the latest amendment we are proposing to delete the word possession for. And in paragraph 3, around the third row, we mentioned a defense. And it says that before offering the food for sale, he would have taken all reasonable steps to ensure that the food was so marked or labeled. Well, would have taken is not that correct. So it suffices if the defendant is only had taken. So we are amending that to take out the word would here. So any question from members? That's a technical amendment. So let's move on. Page 12. These are corresponding changes. Thank you, Madam Chair. Page 12. The Schedule 1. Schedule 1 is only mentioned in paragraphs 2 and of 3 and 5, but then in paragraphs 2 and Schedule 1, then that schedule is also mentioned. So that's why there is a technical amendment here too. Please continue. And that is part 1. So in the heading, there is a corresponding change in milk products and infant formula, because that term was mentioned earlier. Page 14, no amendment. Page 15, no amendment. Page 16. There is a series of amendments, and that is actually with has to do with a typo. We just changed the word "na" in Chinese. And page 19, the same amendment here. Page 20, we add in the part 4, and we list the energy and nutritional composition of infant formula. One plus 33 is the nutritional composition. So it goes on, the list goes on. Page 23. In the 1 plus 33 requirement, Codex has also set some technical requirements. So this division has to do with all these technical requirements. If there is no question, page 24. That has to do with exemption. So that provides for exemption for formula for special medical purposes, i.e. such products will not be required to abide by the requirements on infant formula, well, for the reasons that we explained before. Page 24, Schedule 1A. The English is used under medical supervision. Well, is 医生指示 equivalent to medical supervision? Well, we think it's the same thing. Well, it depends on whether you take a broad or narrow definition. So in the broad terms, medical encompasses people other than doctors, right? So can we be clearer on this point? Well, under a broad definition, medical supervision can be given by a doctor or a nurse. Perhaps Dr. Ho can explain here. Dr. Lang has already made an explanation. The English version is modeled after that in Codex, and the Chinese translation is done here locally. Normally, we would ask the doctors to supervise the use. Any questions from members? All right, let's continue. Page 25, no amendment. Ms. Sit-Ho. Page 24 and 25. It discusses a lot about milk, the labels of milk, skimmed milk, and so on. Separated milk. And I think the infant formula also includes soy milk. I'm not an expert, but can the government officials explain whether there will be a separate labeling requirement for soy milk? Because some babies may not be able to take in soy milk. But for these several labels, they don't cover soy milk. I suppose the soy milk should come under your regulation as well. Is that right? Well, it depends on the nature of the soy milk. If the soy milk is used for some special medical purposes, then that will be subject to the regulations I mentioned. But if it is not the case, it doesn't serve any special medical purposes, then we'll have to see whether it will fall under the definition of infant formula. And under that definition, that the infant formula has to be the sole nutritional source for the a specified group of infants. If the soy milk doesn't fall into those categories, then it shouldn't be covered by the amendment regulation. So perhaps when we go to that point, please explain more to us. All right, let's move on. Page 26, no amendment. Page 27. The amendment is also made in response to Codex's requirement, and that is any container containing follow-up formula must not be marked or labeled to the effect that the formula is suitable for consumption by persons under 6 months old, because the nutritional composition is not fit for this age group. So that has been put there categorically. Okay, please move on. Page 28, no amendment. Page 29, no amendment. And page 30, no amendment. Page 31. Well, this is just to make the wordings clearer. 其本身. And then page 32, no amendment. Page 33. So we now come to Schedule 6A. Schedule 6A lists the nutrition labeling of the 3 products: infant formula, follow-up formula, and prepackaged food for infants and young children. For infant formula 1+29, follow-up formula 1+25, and prepackaged food, separate requirements are set out. You can see that, well, this is a rather long list. I would like to highlight certain points for members' attention. Paragraph 2. We have a requirement on the fluoride content. Page 34, yes.
Number 2. Page 27 in the English version. With regard to infant formula, there is a requirement outside 1+29, because we are aware that a lot of infant formula would have fluoride added. But if there is excessive taking in by infant formulas, the teeth may be affected, that there may be dental fluorosis, and this must be labeled on the can so there can be informed choices made by consumers. Next page. Follow-up formula and the 1+25 requirement. Dr. Helena Wong. Chairman, I have a question, please. We talked about dental fluorosis. That is when fluoride is added. If the PAS is of the view that if there is such addition, then the alertness of consumers should be allowed. Why don't you just stipulate a cap? Why don't you just require labeling? Maybe Dr. Ho can explain to us. What do you mean by dental fluorosis? This is by reference to the practice in other countries. When children have their teeth growing and developing, if there is too much fluoride absorbed by the babies, there could be the case of dental fluorosis. But then this is not a must, even if you have infant formula containing fluoride, because it also depends on the fluoride content of potable water. And the situation is a little complex. And we are proposing that if this limit is exceeded, then there should be labeling, and so the consumers are alerted to this. And if there is a worry, the parents or consumers should discuss with doctors or other healthcare professionals. Chairman, what about potable water in Hong Kong? Do we have fluoride added to it? Yes, there is. So fluoride exists in drinking water in Hong Kong. How much is there? And what is the fluoride content of infant formula sold in Hong Kong? What about manufacturers of infant formula? In other words, is there fluoride in the potable water of those countries? I'm just worried about double dosage for our babies. The question is a little complicated because the adding of fluoride varies from country to country. And also in the processing procedure, whether you boil the water, that makes a difference to the fluoride content as well. We consulted the dental profession when we wrote this provision, and they said that we could make reference to overseas practice, and that is to do labeling for the reference of consumers. I'm worried that consumers may not understand it. Even if there is labeling, they don't know that the situation is so complex. In Hong Kong, of course, people boil their tap water and use it to make milk. They may not use mineral water. This is what I understand people to be doing in Hong Kong. They don't use mineral water to prepare milk. I think you need to avail yourself to the uniqueness of Hong Kong, that in Hong Kong there is fluoride added to the water. Why don't you just set a cap? Since you already know how much fluoride content is in our water, in other words, even if people don't take milk, they are taking in fluoride. Why don't you just set an upper limit? Chairman, allow me to explain. We don't encourage the adding of fluoride that exceeds this indicator, but then there is no hard and fast evidence that the exceedance of this limit will certainly cause dental fluorosis. That is why we like to propose the labeling approach, and therefore we say that they should consult medical practitioners or health professions about the possible risk. From what you know, what kinds of infant formula, if any, exceed such limits? We are not aware of the situation. Well, Chairman, I think we need more information from the Bureau, and that is the fluoride content, if any, of infant formula sold in Hong Kong. And how much is there if fluoride is indeed found per 100 kcal? And maybe we should ask the Water Supplies Department for the fluoride content in our potable water. Can we have such data at the next meeting? Let me add. We consulted the dental profession. The view was that if the limit is exceeded as required under bracket 2, and together with fluoride content in our potable water, then indeed there will be a risk of dental fluorosis. So people's attention should be drawn to this. What I think Dr. Wong's question is, since you know there is a risk, why don't you just stipulate that the cap should not be exceeded? That is better than telling people there is a risk because people don't understand. This is already a requirement. If this level is exceeded, then labeling will be required, and labeling is not required if that level is not exceeded. Chairman, I don't think Dr. Ho has got the question. I understand you, but you don't understand me. I'm looking at this from the consumer's angle, the father, the mother, and the baby. When I give the baby food, I want to know what the food is going to do to the teeth of the baby. In other words, as drafted, you are telling us that there is an effect, but you only ask for labeling. You are not assisting the consumer. The consumers are not a party to this legislative process. Do you expect them to take the can to a dental professional? Few parents will think about the teeth of their babies when they buy infant formula. Why don't we be the gatekeeper when we make the legislation? Why don't you just say that there is this tolerance limit? If you exceed the tolerance limit, you will be breaching the labeling requirement. Can we write that in? We can go back and rethink this, but I like to add that when we wrote the regulation, we must not forget what the international community is doing. On fluoride, many places do not require even labeling. The mainland, Singapore, and US do not require any labeling about fluoride content. We are following the Australian and New Zealand example. But does their water contain fluoride? Well, we have to ask the CFS. I just like to say that we need to strike a balance. Since we do not manufacture infant formula, we have to be mindful what is happening in other countries. Now, since there are countries that do this, so we have to strike a balance between our situation and the rest of the world. Well, I think the PAS does not understand my concern. Of course, we know we don't manufacture infant formula. The thing is whether people add fluoride to their water. I mean the manufacturing countries. If you introduce food into Hong Kong, and of course we know that in our potable water there is fluoride addition. It seems you still don't get the question. But it's all right. Just let us have the information at the next meeting and tell us how much fluoride is added into the water of Hong Kong and other countries. If Hong Kong is the only place that adds fluoride to our water, then if there is infant formula that also has fluoride, then I think we want to do more with the labeling requirement. Dr. K.K. Kwok, Chairman, I understand the request made by Dr. Wong. When we discussed nutrition labeling long time ago, we faced the same issue. When there is a new label, the officials or the importers might say, we are such a small market and there are people who don't want to do anything special for us. But I don't think this is an excuse for us not to protect the consumer. Number two, we all understand that such labels must be written in English and Chinese. When Australian infant formula comes to Hong Kong, it has to add a Chinese label to it. I don't think the manufacturing country can let us have a Chinese label. So the Chinese label is going to be added in Hong Kong. So in any case, it has to add a label in Chinese in order to comply with our legal requirements. We are only just asking for one more piece of information, and you can do it in a few ways. You do it by way of law and regulation. Number two, now you use the denominator as 1,100 kcal or 100 kilojoule, and Why don't you just tell them or us what the risk is like? Say if this level is exceeded, then the baby might have a risk of dental fluorosis. Wouldn't that be better? You do so much just because you don't want babies to be affected by dental fluorosis. So why don't you go for a simpler, easy to understand approach if that is what you want to do? And as Dr. Wang said, since you are already doing so much, why don't you just require that a baby should not be exposed to a level higher than that limit because of the risk of dental fluorosis? I'm sure the Medical Association will be very happy with helping you with the daily limit of exposure according to body weight. Maybe Dr. Ho has the data, the daily exposure limit on the basis of body weight. Can you let us have such data? If a baby relies solely on infant formula, can you convert it to body weight limits? Say if a 6-month baby, 12-month baby weighing a certain number of pounds, and what is the daily limit? Chairman, we are proposing the labeling approach as explained by Mr. Leung. This is because we are following the example of some countries. We say there is a risk if this level is exceeded. And so we would ask the label to include 2 pieces of information. 1, that the consumption of this formula may cause dental fluorosis, and 2, if they should still choose that product, they must discuss with a medical practitioner or a health professional. It really has to be assessed by a medical professional. This is an infant formula, but not all babies would rely solely on this product, because some babies are at the same time breastfed. And there may be a range of different scenarios, and therefore the assessment must be done by a doctor. When we consulted the dental profession, if babies rely heavily on this product and if the limit is exceeded, and if there is also a high content of fluoride in our potable water, because fluoride can vary in level in different regions. And as I said, there will be a slight difference if water is subject to boiling. Therefore, it really depends on the circumstances of each case. And when we say infants, they may be newly born or 6 months old. And therefore, the level that would be exposed, that they are exposed to, will vary. When you choose this infant formula, you have to consider whether you use it for a newborn or starting from 3 months or 4 months.
So after studying into the matter, we think that the present proposal, i.e. having it labeled on the product, then that would be appropriate. While we are not encouraging such products to be offered to infants, if you do that, you have to have these 2 pieces of information. Well, for consumers, where they don't understand too much, and they said where they look at it and it may cause dental fluorosis and has to discuss with the doctors, and then they may have a second thoughts about using the product. But then if we are not allowing such products to be sold, then that's not the practice in overseas jurisdictions. I agree with Dr. Ho's views. We should not ban them from being sold. You said very clearly, not every product has such a fluoride content, then that's okay. But if the content exceeds 100 UG per 100 kcal or 24 UG per 100 kilojoule, I think you should put a ceiling to the content. Well, the limit actually is related, should be related to the body weight of the babies. And say if a baby is 5 kg or 6 kg heavy, then we can make recommendations on the upper limit of the fluoride intake. I think that shouldn't be a problem. You shouldn't be asking the consumers to take the labels and consult the dentists. I don't think the dentists can answer your questions. I can bet with you on that. I don't think dentists are very knowledgeable on such issues. So can we do more? A, B. You should add in C. You should say recommended level per day. At what level? So then, well, then the consumer then can multiply that with the body weight, and then they would be able to know the appropriate level of intake. So perhaps the administration can go back and consider again. Members wish that you should make it clearer to consumers the kind of risks that will be posed to infants if such products are being bought. Now, since you do have the standards on the content, and you said you have already consulted the dental profession, can you go back and consider again how it should be written in a clearer way so that consumers can understand more? As what Dr. K.K. Kwok said, consumers have difficulties in comprehending this. Well, all I know now from reading this is that too much intake of fluoride is not good and is not good for our teeth. So can you make clearer provisions on this part? And Dr. Helena Wong also requested for information that can be provided to us later. Well, later you can provide us with the information on the fluoride level of potable water in different places. But I think what you can do now is to, before the next meeting, give us a recommendation how you can word this paragraph more clearly. Sorry, speaker's not coming through. I hope that the information will be available in the next meeting. For Hong Kong, for the potable water in Hong Kong, how much fluoride content is there? We should have such a standards, right? Well, we're holding a meeting several days later, so in the next few days, whatever you can give us. Now, say the fluoride content of potable water in Hong Kong, and also you said that you have consulted dentists. What kind of information have they provided to you? Can you pass on the information to us as well? And also for the formula products sold on Hong Kong market, do they contain fluoride content, and how much? I think it has not. It is not to do not just with dental fluorosis. We have had a long debates on the fluoride content of potable water, the brain, your bones, and your thyroid glands will also be affected if you take in too much fluoride. So perhaps apart from the dentist, with the other doctors be having an opinion on this as well. So I think we have to tread carefully. Later on, the CFS would be submitting a report on the formula products sold on the market. So please give us that information. You please give us information on what basis you think this provision is needed. As what the Madam Chair suggested, we would go back and see how we can respond to members' questions. We would talk with the CFS. What we want in the main is that you should word the provisions clearer. Madam Chair, can the administration tell us the information or on the fluoride content per liter of potable water in Hong Kong. I don't have the information on hand. Perhaps in the next few days, in the next 2 days, we will try to do our best to give you the information. Yes, please do your best. Well, at least you should have information on the local situation. Yes. Madam Chair, I have to apologize. I'm not very familiar with reading this document. Ms. Sit-Ho's raised a question about definition, and I skipped that part. Actually, starting from page 5, I've skipped certain sections. So let me move back to page 5. I have gone through the FSMP, and the first definition is niacin. Page 5. There are certain definitions for products to be regulated. Their compositional requirements and also their definitions are listed. Folic acid. That would come under regulation, so we have to make a definition for that. So that is also drawn up taking reference from Codex. And page 5 contains certain definitions mentioned by Ms. Sit-Ho. So I would like to talk first about infant formula on page 6. There are 2 parts. Let me first talk about B, which is simpler. Well, in the market, there are products which are called infant formula or marked or labeled as such. So for such products, they will be regulated as infant formula. As for A, it is a detailed definition. A product that, according to its descriptions or instructions for use, well, for a product, we have to look at the label and how it describes itself. Another requirement is that in the descriptions or instructions for use, it is meant for consumption as a substitute for human breast milk. Another important phrase is that is to satisfy by itself the nutritional requirements of persons of any age up to and including 12 months, so that this is a sole source of nutrition for the baby. So before complementary feeding can be provided. So this definition is based on the definition under Codex. Age limit, we set here, include up to including 12 months. And that also is modeled after the Codex approach. Ms. Sit-Ho, can I ask again? I asked a question about soy milk because in page 24 and 25 there are several labels here which says that they should not be fed to infants under 12 months old unless under medical advice. So some babies need, for special reasons, have to feed on soy milk. So is it the case that soy milk should be administered under the supervision of doctors, or the parents can take the initiative? So what about these labels here? Why don't they cover soy milk? Well, I asked the doctor next to me just now, and he said that soy milk will not hurt your health. But then he added that he's not a pediatrician. So perhaps the administration, can you confirm a baby under 1 year old and he is feeding purely or mainly on soy milk for his nutrition? So should that be done under medical supervision? If that is the case, these several labels should also cover soy milk. Now, if that is not the case, it is under the initiative of the parents and or other medical professionals, and if that is acceptable, then there is no need to cover it here. If you look at page 24, these are the existing arrangements or requirements. They're not targeted at the infant formula being discussed. Using our proposed definition, while we don't have any limits or constraints, can be soy milk or goat milk, as long as they can meet with the nutritional composition, then that's acceptable. Now, if the babies are feeding on the kinds of milk appropriately, then that's acceptable. No problem. Well, we are about to end the meeting, and after 4:30 we will have another meeting, and many of us will have to attend that. So perhaps we should end here. And the PAS, please consider our questions raised, and especially the question on the fluoride, and respond. Next meeting is the 17th of October, 10:40 a.m. So please try to give us the information we requested. So, yes, we'll do our best. 10:45. Members, AOB? If not, thank you very much. We'll see you in the next meeting.